Scott, can you remember to keep your voice up, won't you?
I'm grateful, Lord. I'll endeavour to do that.
Thank you.
Lords and my lady, we were looking before the lunch break at the classic exercise in terms of Article 8. And we discussed the issue of legitimate aim. And the next part of the exercise is to consider whether the limitation which has been imposed on those who may appear at the children's hearing or participate in the children's hearing is necessary in a democratic society. Now that involves addressing whether there are relevant and sufficient reasons for that limitation. And in that context, what the court will be looking for is whether there is a pressing social need to demonstration that the limitation that we're looking at is proportionate to that need. And of course, we're looking here at a limitation on access or participation in decision-making in a forum where there is no equivalent limitation that I know of in any other Scottish forum or Northern Ireland or English forum. It's just the children's hearing that imposes this sort of limitation on participation. And if I can develop the argument on the issue of pressing social need...
Can I just see if I've grasped that point? You're saying that one finds built into our statute restrictions on the argument against you, which you wouldn't find normally if the whole matter was left to the ordinary courts to determine. Is that the point?
There is no limitation, as I understand it, no equivalent limitation on access to ordinary courts. People have to perhaps claim an interest or seek leave or whatever it might happen to be, but there is nothing equivalent to the limitation which is imposed in this particular forum on an appellant, on a person such as the appellant. And what I was proposing to do now is to look at this issue of pressing social need. And my first argument on that is that there is actually a surprising discontinuity between the limit on the access to decision-making in the children's hearing and the involvement of an unmarried father such as the appellant in other equivalent or almost equivalent contexts. And the first part of this argument focuses on the Children's Scotland Act itself and the involvement that a person such as the appellant is expected to have in relation to the social work department. Now, if I can take my lords and my lady to the Children's Scotland Act again at tab 10. And to the beginning of part 2 of the Act. This child is...
Where does part 2 begin?
Part 2 begins, my lord, on page K351, and I'm going to take the court to page K352.
Okay, sorry.
351, 352.
Thank you.
You cover this point, I think, in paragraph 2.4 of your case, don't you?
I probably do, yes.
Well, I mean, it's just that we've got the references there. Which,
yes,
yeah.
I'm grateful, yes. My point here is that this is a looked-after child, falls within the definition of a looked-after child in section 17, subsection 6 at B, because she's subject to a supervision requirement. And insofar as the local authority are concerned, they are bound to ascertain the views of, to consult with all parents in terms of 3B, subsection 3B.
And parents, it just means what it says.
Parents just means what it says, yes, absolutely. That obligation is developed in regulations. The current regulations are the Looked After Children Scotland regulations, which are found at tab 35. On page 5 of those regulations, at part 2, there is provision for care planning. Regulation 3, this regulation applies where a child is looked after or about to be looked after by a local authority in terms of section 17.6, so that applies to children subject to supervision requirements. A care assessment is required, and in terms of regulation 4, sub-regulation 2, in making an assessment, the local authority must, where appropriate, seek and take into account the views of B, the child's parents. And then in terms of the care plan, 5, 2, before preparing the child's plan, the local authority must, so far as reasonably practicable and consistent with the best interests of the child, consult with B, the child's parents. And I could go on through these regulations, and I could go on into their predecessor regulations, 1996 regulations, and they refer to the involvement of the parent without qualification. And there are other aspects that I'm not going to go to, but are noted, I think, in my case in relation to child protection orders and parental responsibility orders, which refer to parents without qualification. When it comes to the child's education, a parent is inevitably involved in relation to education, and this comes in the Education Scotland Act at tab 19. The relevant section to start with is the definition section at the end, towards the end of that tab, at section 135, on page F113.
So we have a definition of parent in this act.
We have, yes. Parent includes guardian and any person who is liable to maintain or has parental responsibilities in relation to or has the care of a child or young person. Now, of course, all unmarried fathers have a liability to maintain their children. Both in terms of...
Forgive me, where do we find that?
I'm at F113 in tab...
Ah, yes.
I'm so sorry.
No, sorry. It's because of the side note. Yes.
Yes, but it's an extended definition, though, isn't
Yes,
it? Anyway,
it is,
because
it is.
You would say the unmarried father qualifies under the ordinary meaning of the word parent without the extension.
Well, in terms of the Education Scotland Act, there is a special definition, but it includes all persons liable to maintain. And
Yes.
of course, unmarried fathers are liable to
I
maintain,
see.
both in terms of the Family Law Scotland Act and in
Yes.
terms of the Child Support Act.
Okay. Perhaps you can help me with this. Until 1987, and I notice this is an old Act of Parliament, until 1987 in England and Wales, the word parent in any statute did not include unmarried fathers. We then passed the Family Law Reform Act 1987, which in section 1 has a provision which basically says any reference anywhere to a relationship shall be construed without regard to whether or not anybody's parents were married to one another. Thus meaning that the word parent thereafter always included unmarried fathers as well as married fathers. Now, I believe you have a similar provision in Scotland.
The Law Reform Parent and Child Scotland Act was the act which abolished illegitimacy, if one could put it that way.
Yes.
It's at tab 34. It doesn't quite go so far.
Well, I know from correspondence with Professor Clive that they were quite attracted to that.
The Law Commission, the Scottish Law Commission, were indeed attracted. But what they got was the Law Reform Parent and Child Scotland Act in 1986. which provided
Yes,
for
well-
legal equality of children by saying the fact that a person's parents are not or have not been married to one another shall be left out of account in establishing the legal relationship between the persons and any other person. Accordingly, any such relationship shall have effect as if the parents were or had been married.
Well, that produces the same effect.
Yes, but it doesn't actually affect the issue of parental responsibilities and rights.
Nothing to do with parental responsibility. That's not the point I'm making. The point I'm making is what the word parent in an Act of Parliament means.
Yes, and you apply subsection 2 of section 1, don't you?
Because of, yes.
Yes,
I can see that.
this is definitely producing the same effect
Yes.
as the 1987 Act, but it was 1986, of course, and we're
course.
construing a
Yes.
statute in
We're a little in
1980.
advance. On the other hand,
parent in this particular act is defined as including
yes,
guardian. It's not necessarily an exhaustive definition.
no,
As my lady points out, parent can also comprehend, by reason of the other legislative provision, the father in this case.
yes. My point in relation to the education legislation, my lords and my lady, was that the father has the responsibility to educate his children in terms of this act. And if I can just take the words very briefly to the legislation, Section 28 provides for pupils to be educated in accordance with wishes of parents.
Sorry, which act are we on now?
Still the Education Scotland Act.
Back to the 1980 Act, are we?
Indeed so.
So section 28,
Section 28, education in accordance with wishes of parents. 28A, the right to make placing requests for one's child to attend. 28C and following, the right to appeal or refusal of a placing request. 28H.
just this is rather complicated. I'm looking at the 1986 Act, section 1, subsection 4A, because Lady Hill is quite right that at first sight the 1986 doesn't apply to the 1980 Act, but if there's an amendment, and you need to see the list in the schedule, and it would apply to the Act as amended. Now, I don't know whether you're suggesting that the meaning of the word parent is extended for our purposes, or whether we're still having to apply the reference to people liable to maintain.
For the purposes of my argument, it doesn't matter.
It doesn't matter.
Because for the purposes of my argument, this father has all these rights and responsibilities in terms of the child's
Yes.
education.
Right, thank you.
What do you say the effect of section 1.1 of the 1986 Act is?
I would say it means that when we see the word parent, we interpret it as parent without qualification as to whether or not the parents are married.
And how does it affect the 1995 Act, if at all?
The 1985 Act deals with parents as natural parents, and so when we look at the references that we've seen in Part 2 to parent, it includes all parents, regardless of whether they're legitimate or, in the old-fashioned term, illegitimate, whether or not the parents have been married. But it doesn't affect responsibilities and rights, because responsibilities and rights are limited in terms of sections 1, 2 and 3. And it doesn't affect relevant person, because relevant person is expressly defined in section 93(b).
That's the point.
But it's drafted on the assumption that parent means parent.
Absolutely. I'm grateful.
It just draws a distinction between parental rights and responsibilities and so on. But it's certainly drafted on the assumption that parent means parent.
Malone Jr. points out that, of course, parent is also defined in section 15 of the Children of Scotland Act. It's almost as if we've forgotten that section 1.1 exists.
That's what I was trying to get at.
Yes. Well, we're looking very quickly at the 1980 Act. Is Section 28 enough for you, or do you need to see?
I can simply list the responsibilities and rights in the sections. Section 80 provides, 28 as we've seen, it provides for education in terms of the child's wishes, the parents' wishes. Section 30 is important because it imposes a duty on the parent to provide education for the child.
Yeah.
Section 35 is important because it provides for the prosecution of a parent who does not fulfil that duty. Section 36 is important because in terms of Section 36(3), if a child does not attend school regularly and the education authority concerned, they can refer the child to the principal reporter. Now we'll see where I'm going. So one can be prosecuted. The child can be referred to the reporter. And if one's in the position of the appellant, the minute the child gets there, one has no further locus to participate in the decision-making. And the incoherence is perhaps further established if one looks at the Children's Scotland Act itself, where a court that is concerned about a child and thinks that measures of protection are necessary for that child can, in terms of Section 54, refer that child to the reporter. So one can move from a court of session or sheriff court action in which a father is fully involved to a referral by the court under Section 54 to the reporter. This is on page K372. Whether in relation to parental responsibilities and rights generally, or proceedings for prosecution of a parent under the Education Act. And from proceedings where the father is fully involved, he's suddenly excluded. What I say about that is it calls into question the pressing social need that one's looking at in terms of Article 8.2. Now, I'm conscious that the answer which is provided by the principal reporter, and indeed I think by the Lord Advocate, is that the unmarried father can, of course, start sheriff court proceedings or court of session proceedings and look for parental responsibilities and rights. And the issue for the court is whether that is proportionate, whether that meets the pressing social need to require him to do that. And if one looks at the process of what the unmarried father has to do, he has to start sheriff court proceedings. Now, he may have no legal representation because you don't need legal representation in the children's hearing. So he has to go off and find himself a solicitor. He either has to have the money or he has to make an application for legal aid. There's an issue of timing because by the time he's done all this, the chances are that the grounds of referral will be established. With all the consequences that might have that we looked at earlier. And then he has the problem of what orders to ask the sheriff for. Because if the children's hearing has already rolled its sleeves up and made orders, the court can't make orders which conflict. Or shouldn't make orders which conflict.
Can the sheriff order this children's hearing to pause in its... No. There's no power to do that.
There's no power to do that. And also there's a statutory timetable, of course, for proceeding from the referral hearing to the sheriff court. The reporter has 7 days to take the matter to the sheriff in terms of the rules, and the sheriff must hear the case within 28 days, or should start to hear the case within 28 days. And so the timing becomes quite impossible. And then we have the whole issue of what test, if one can identify the orders which might be sought, one has the issue of what's the test, because what one's asking the unmarried father to do, and I don't want to repeat what's in my case, is to satisfy the welfare test before the sheriff in order to go and discuss welfare in the children's hearing. And there's a whole circularity there. And it's a higher test than the test for family life in terms of Article 8. And of course, in this case, the father is presented with opposition from the mother. And I'll come back to that in a moment. Now, I appreciate that we're dealing with a domestic case, and therefore the margin of appreciation is not directly relevant, but we've already looked at Elsholtz, which says that there is a narrow margin of appreciation when one's looking at protection of the right to respect for family life. But there, of course, are equivalent comments in the more recent case of Sahin, which is at tab 70 in the bundle.
Did you say 17?
70.
70.
And I'm looking now at page 684.
Yes.
Sahin was one of two contact cases, access cases, brought by fathers in Germany, unmarried fathers in Germany. And in both cases, there was a refusal of access. So the court was looking at the substantive issue rather than the access to the court. But if one looks at paragraph 65 in Sahin on page 684, the court says, repeating Elsholtz, the margin of appreciation to be accorded to the competent national authorities will vary in accordance with the nature of the issues and the importance of the interests at stake. Thus, the court has recognised the authorities enjoy a wide margin of appreciation, in particular when deciding on custody. However, a stricter scrutiny is called for as regards any further limitations, such as restrictions placed by the authorities on parental rights of access, and as regards any legal safeguards designed to secure the effective protection of the rights of parents and children to respect for their family life. Such further limitations entail the danger that family relations between a young child and one or both parents would be effectively curtailed. And then at 68, the court considers it cannot satisfactorily assess whether the reasons were sufficient for the purposes of Article 8.2 without at the same time determining whether the decision-making process seen as a whole provided the applicant with the requisite protection of his interests. In that particular case, it was thought that there had been requisite protection. But of course, that's a very different case from the present one.
Well, the Chamber didn't.
No, the Chamber didn't, but of course we were reversed by the court, the whole court.
Well, I'm only making the point because it indicates that it was a touch-and-go thing, in a way.
It was narrow. And I'm coming back to this case, of course, in relation to the Article 14 point. I won't take the court to Summerfelt, but Summerfelt, there was a similar decision at paragraphs 63 to 75. There's one other point to make before I leave this chapter of margin of appreciation, and it's this. The argument against me, I understand, was that there was a consideration of whether unmarried fathers should have automatic parental responsibilities and rights. The Scottish Law Commission was in favour, Parliament decided against, it was considered again. But that, with very great respect, my lords and my lady, is not the issue in this case. We're not talking about whether there should be automatic parental responsibilities and rights. We're talking about whether this person should be involved in or participate in the children's hearing, which is quite a different matter.
But you do say that that should be an automatic right.
That is part of my argument. To be involved, to participate.
So there's no there's no room to take anybody out. Any exceptions from the?
I have a position and a fallback position, which I'll come to when I come to discuss how my Lords might read in or read down the section. My primary position is nobody should be out, but my secondary position is that at the very least, those who have Article 8 rights to respect the family life should be in. And at the very least, the test should relate to those rights rather than something different, and the test here is something different.
I ask the question simply because of what you see in paragraph 67 in Sahin. And I suppose there's a point in these cases that if you get allegations of the kind that are made here, and the account which one sees repeatedly in the children's hearings reports of the attitude of various parties to the case, it may be said, well, to introduce the unmarried father would cause disturbance to the development of the child and so forth. It's not a category so much as an individual exception. Now, the case against you, I suppose, is a general problem for you at the very start. And that's the point you're attacking just now. And I just wonder how far it could be driven if you're down to the individual and the nature of the particular case.
Well, what I would attack would be the assumption that unmarried fathers who don't have parental responsibilities and rights are going to cause problems in the children's hearing. It's much too broad a proposition, and I'm to Zorneger and
Yes.
the ratio of Zorneger in that.
Follow that. Yes.
And what I would say about the unmarried father, or a particular person causing difficulties in the children's hearing, well, it could be a married father, it could be a mother, it could be anybody
Yes.
who is entitled to be there. And the children's hearing are there as a tribunal to use their skills and deal with that.
A provision which permitted the exclusion of a particular unmarried father because of the circumstances such as are adumbrated in paragraph 67 might not offend Article 8, but a provision which excludes all and requires them to overcome the hurdle, you say does.
Yes, yes. I'm grateful. Now, unless I can assist my Lords further on my second proposition, I would propose to proceed to Article 14.
Yeah.
And my starting point on Article 14 is the decision of the Lord sitting as the House of Lords in Guyton against Godin and Mendoza at tab 25. Now, I was proposing to take as my starting point Lady Baroness Hale's speech starting at paragraph 133 on page 605.
I have a feeling we've rather moved away from Michalak now.
Well, yes, but on the other hand, it's a convenient point of reference. I see that we needn't adhere to it too precisely. But as a tool of analysis, what I was going to say is that in terms of the first original question, we're in the ambit of Article 8, that's not disputed. Second, is there a difference of treatment in relation to comparators? And I say the comparators here are the mother and the married but separated or divorced father. And I take those comparators from Sahin and Zarniger. I can state briefly, I don't accept the principal reporter's assertion that appropriate comparators are parents who have had but have been deprived of parental responsibilities and rights, because, of course, there's then a court decision to deprive them. And so there's already a decision on merits. I'm dealing with people where there's been no court decision. The third question is, are the comparators in an analogous situation? Well, I say that the comparators are parents with a right to respect the family life whose children have been referred to the children's hearing. The fourth question, and what I submit is the key question, is was the difference in treatment objectively justifiable? That is, did it have a legitimate aim, and did it bear a reasonable relationship of proportionality to that aim? That's the difference in treatment I'll come back to. And was the difference based on one of the prescribed grounds? Well, of course it was. In Re G, we have a status of being unmarried here. So the focus has to be on, was the difference in treatment objectively justifiable? Did it have a legitimate aim? And did it bear a reasonable relationship of proportionality? Now, it really is not for the appellant to identify the aim, but one can't judge proportionality until that aim has been identified. The context is involvement in the decision-making of the hearing. We're still not arguing about who should have parental rights or responsibilities or the merits of any decision. But what we have to identify is what is the aim of the difference in treatment in this case. And that, I would respectfully submit, is quite difficult to see. And that really takes me back to Sahin.
So back in tab 70.
Yes. Where there was agreement between the Chamber and the Court. The Article 14 case in Sahin starts at page 687. The Court looks at Article 14, it discusses the Chamber's judgment, and it deals with the Chamber's judgment in more detail slightly later on, so I will move over that. And perhaps take matters up at paragraph 85, where the conclusion of the Chamber is dealt with. The approach taken by the German courts in the present case reflects the underlying legislation, which puts fathers of children born out of wedlock in a different, less favourable position than divorced fathers. Unlike the latter, natural fathers have no right of access to their children, and the mother's refusal of access could only be overridden by a court when access was in the interests of the child. Under such rules and circumstances, there was evidently a heavy burden of proof on the side of the father of a child born out of wedlock. The crucial point is the courts did not regard contact between the child and the natural father prima facie as in the child's interests. And then at the bottom, there's a concern about natural fathers being treated less favourably. So in the Chamber's judgment, for the purposes of Article 14, a difference in treatment is discriminatory if it has no objective and reasonable justification, if it does not pursue a legitimate aim, or there's no reasonable relationship of proportionality between the means employed and the aim sought. In terms of the Court's case law, very weighty reasons need to be put forward before a difference in treatment on the ground of birth out of wedlock can be regarded as compatible with the Convention, and the Court wasn't persuaded by the government's arguments that fathers of children born out of wedlock lack an interest in contact with their children and might leave the non-marital relationship. And then there's the point about a change in the law, which dealt with those problems, but the Court wishes to make it clear that these amendments cannot themselves be taken as demonstrating the previous rules were contrary. They do, however, show that the aim of the legislation in question, namely the protection of the interests of children and their parents, could have been achieved without distinction on the ground of birth. And then at paragraph 92, in the present case, in the inevitable situation of difference between the parents as a consequence of the mother's deep dislike of the applicant and opposition to him, the courts found that under the relevant civil code, only special circumstances could justify the assumption that personal contact with the applicant would nevertheless have permanently beneficial effects on the child's well-being. Having regard to the fact that these courts were convinced of the applicant's responsible motives, his attachment to the child and his genuine affection for her, they place a burden on him which is heavier than the one on divorced fathers. And then at 93, as is well established in the Court's case law, a difference in treatment is discriminatory for the purpose of Article 14 if it has no objective and reasonable justification, and so on. 94, the Court has already held that very weighty reasons need to be put forward before a difference in treatment on the ground of birth out of or within wedlock can be regarded as compatible with the Convention. The same is true for a difference in treatment of the father of a child born of a relationship where the parties were living together out of wedlock as compared with the father of a child born of a marriage-based relationship. The court discerns no such reasons in the incident case. And of course, there's a similar critical passage in the Summerfield, the equivalent case, which is at paragraphs 92 and 93. Now, of course, I pray that in aid in this case, in challenging the difference in treatment. I also pray in aid the more recent case of Zorniger, which is at tab 73.
Tab number?
Tab 73, Zorniger. This is a judgment of the fifth section. It's not the whole court, unlike Sahim. But it was a case where a child was born out of wedlock. The parents reached an agreement about the time the child would spend with the father, and the father asked the court for a joint custody declaration in order to regularise the terms of the agreement. That application was refused because in German law, in the case of parents of children born out of wedlock, the consent of the mother was required for the joint custody order. An appeal was dismissed. The Federal Constitutional Court declined to hear the case. And it was held by 6 votes to 1 that this was a violation of Article 14 taken together with Article 8. The alleged reasons for difference in treatment are put forward at paragraph 29. The government submitted that a particular article of the Civil Code was founded on the differences that existed in the respective environments into which children born out of wedlock were born, ranging from father-child relationships which were intact to those where the father was indifferent. With the primary assignment of parental custody to the mother, whose identity, in contrast to that of the father, was established at the time of birth, the intention was to have a clear allocation of the right of custody for the purpose of legal certainty, so that from the outset there would be binding determination of the statutory representative for the protection of the child concerned. The approval requirement applying to both parents for the joint exercise of parental custody was based on the notion that parents who could not agree to make a custody declaration were highly likely to come into conflict when specific questions relating to the exercise of parental custody were at stake, which could cause painful disputes which would be detrimental to the child's interests, which was the point that Lord Hope was putting to me a little while ago in relation to the children's hearing. The father's complaint is at paragraph 43. The court notes the applicant in his capacity as the father of a child born out of wedlock complained first of difference of treatment in comparison with the mother, in that he had no opportunity to obtain joint custody without the latter's consent. Secondly, he complained of difference in treatment in comparison with married or divorced fathers who were able to retain joint custody following divorce or separation from the mother. And then, looking at the court's decision, the point to start is probably paragraph 53. The court accepts that in view of these different life situations of children born out of wedlock and in the absence of joint declaration on parental authority, it is justified for the protection of the child's interest to attribute parental authority over the child initially to her mother in order to ensure there was a person at birth who could act for her in a legally binding way. So that was all right. Second, the court further accepts there may exist valid reasons to deny an unmarried father participation in parental authority. But third, nothing establishes that such an attitude is a general feature of the relationship between unmarried fathers and their children. And then at 57, towards the end of that paragraph, nevertheless, the applicant was excluded from the outset by force of law from seeking a judicial examination as to whether the attribution of joint parental authority would serve the child's best interests from having a possible arbitrary objection of the mother to agree to joint custody replaced by a court order. So he was excluded from challenging that. And then at 59, having regard to the considerations, the court cannot share the assumption that joint custody against the will of the mother is prima facie not to be in the child's interests, while having regard to the wide margin of appreciation of the authorities, in particular when deciding on custody-related matters, the court also considers the evolving European context in this sphere and the growing number of unmarried parents. The court reiterates in this connection the Convention is a living instrument which must be interpreted in the light of present-day conditions. The court observes in this context that although there exists no European consensus as to whether fathers of children born out of wedlock have a right to request joint custody, even without the consent of the mother, the common point of departure in the majority of member states appears to be that decisions regarding the attribution of custody are to be based on the child's best interests, and that in the event of a conflict between the parents, such attribution should be subject to scrutiny by the national courts.
That strikes me as quite an important paragraph when you look at the argument against you in the reporter's case in paragraph 63.
Indeed.
You may not remember this, but this is where the point is made that Scotland has retained the distinction between formal and informal relationships in the allocation of parental responsibilities and parental rights and so on. So it's arguing really for the status quo, but this paragraph suggests there is a movement which is perceived in Strasbourg across the member states. Incidentally, in that paragraph, it said that the distinction has been retained, the old approach, if I can call it that, is retained for the Human Fertilisation and Embryology Act in respect of married persons and those in a civil partnership. Is there anything in that point?
I'm not sure. I think I'm going to leave that to Miss Wise to argue. Because my point here is not so much about attribution of parental responsibilities. I go back, my point here is the access to the court to argue about it.
Yes.
And what happened to the father in Zorniger was he wasn't permitted to go to court to argue about it. And in my case, I'm not permitted to go to the children's hearing to be involved in the discussions there.
The other point which I think is taken against you here is that if you look back at section 93(2)(b), it isn't actually, it said, discriminatory at all. Now you just meet that argument head on, as I understand it.
Absolutely,
say, well, just
absolutely.
Look at the effect on the individual.
I say if you draw a circle and certain people are in it and certain people are outside it, then of course those who are outside it are discriminated against as compared with those who are inside it. And the line that is drawn is a line drawn based upon status, because it's fathers who are not married and have not managed to bring themselves within the circle by various of the means that are available. And the only means available to this father would be an application to the court. Of course, in Zorniger, what the court goes on in 61 to say is that the domestic law provides for a full judicial review of the attribution of parental authority and resolution of conflict between separated parents in cases in which the father once held parental authority, either because the parents were married at the time of birth, had married thereafter, or had opted for joint parental responsibility. In such a case, the parents retain joint custody unless the court, at the request of one parent, avoids sole custody to the latter in the child's best interests. The court considers the government has not submitted sufficient reasons why the present situation should allow for less judicial scrutiny in these cases, and why the applicant who has been acknowledged as a father has acted in that role should be held in this respect to be treated differently from a father who had originally held parental authority and later separated from the mother or divorced. In view of the above considerations, the court concludes that in respect of discrimination at issue, there was not a reasonable relationship of proportionality between the general exclusion of judicial review of the initial attribution of sole custody to the mother and the aim pursued, namely the protection of the best interests of the child born out of wedlock.
Mr. Scott, I mean, is the you've chosen? I mean, and just so I understand you focus on 93(2)(b), whatever it is. Mm-hmm. Why do you focus? Just so I understand, why do you focus on that rather than on section 3, 1A and B, where the division is made? Because this only refers back. I mean, this sort of says, well, you define relevant person by reference to the parental rights and responsibilities. I just why does that?
Because the order that all this started, that triggered the petition for suspension in this case, related to being able to go to the children's hearing. And the argument has always been confined and focused on that order. The point for this father has always been, can I go to the children's hearing? Can I argue my case, either to have the hearing determine custody or perhaps to discharge the referral to allow me to go to the sheriff court or to withdraw the condition to allow me to go to the sheriff court? arguing for full parental responsibilities and rights for unmarried fathers is a much wider issue, and I didn't consider that I had the basis to do so.
But you think, and so just so I'm clearing my mind, that 3, 1A and B may be all right,
I'm not having to argue that.
but still, if you use that division in this particular context, then it isn't all right. Is that the way you...
I'm saying it's the wrong proxy. It's the wrong test. I'm saying that the test for involvement in the children's hearing should be a test under Article 8 of the requirement to be involved in decision-making in relation to the child. I don't need to say anything as broad. I don't need to tackle such a big issue as full parental responsibilities and rights to succeed in this case.
As I understand it, your point is, if family life has been established between you and your child, you should have the procedural protection, which is required by Article 8, in relation to decisions about that child's future.
Absolutely.
It's as simple as that is what
Very
you're arguing.
straightforward.
Yeah.
That's, just clear in my mind, that's the using this implied procedural part of Article 8, is that right?
Yes, yes.
So you don't need to go to 6.
Well, I don't need to go to 6. I will go to 6 briefly.
Yeah, but
It's part of my case. But
you say in order to Article 8 contains within it, where necessary, some certain procedural obligations.
yes, as is recognised right from the very earliest stage in REW.
Yeah.
Now, what I have to do, my lords, is tackle head-on the case of McMichael. I probably ought to.
Okay.
I'm sure my learned friend will if I don't. Tab 66.
So where are we going to now?
McMichael against the United Kingdom,
Yeah.
which is the principal case against me.
And the volume and tab?
66 in volume 6.
This is probably an unfair question. Does McMichael get picked up and referred to in any of these more recent, this whole series of German cases? You know, we've got Eltholz, we've got Sahin, we've got Summerfield, we've got Zaunegger. Is McMichael ever kind of picked up and referred to?
What's one of my points, that it's really rather left behind. It's been referred to in other cases.
Well, it is actually listed at page 673 in Sahin.
Yeah.
Yeah,
I
possibly
mean,
that's right.
it may be only just in a tiny, tiny footnote,
Yes.
but I mean,
I
it's
need
not
to deal with it.
entirely
Yes,
forgotten.
yes. I think I do need to tackle it.
But it's rather important to keep an eye on the way the cases are developing and not get too tied down to the old
Exactly.
ones.
And this is an old case. And the reasoning looks pretty dated now if one looks at it. If one looks at the case itself, the facts which gave rise to the case occurred in the late 1980s. And if one remembers the social changes since the 1980s, it happened quite a long time ago. The application was 1990 and the decision was issued in 1995. And it involved an unmarried father who, with the mother, living with the mother, was trying to tackle the pending adoption, freeing for adoption of their child. Now, the judgment of the court starts at starts at paragraph 71 on page 234. And the first point related to Article 6, and I've got to come back to this when I come to tackle, very briefly I hope, my Article 6 case. Mr McMichael didn't have any parental rights, and we were then in the old parental rights regime, and he was held not to have an Article 6 case. He hadn't applied for any, he didn't have any. But Mrs McMichael did have parental rights, and she had an Article 6 case which was sustained on the basis that she didn't have access to reports. But there's an interesting paragraph here at paragraph 77. Under Scots law, Mr. McMichael, as the natural father of a child born out of wedlock, did not automatically have parental rights in relation to the child, such as rights of tutory, custody and access. Nor did he make an application for an order for parental rights, as he could have done, an application which at least from 18th February 1988, when his name was added to A's birth certificate, would have been dealt with in a speedy manner, given the mother's consent. And there's a reference back to paragraph 43, where the law is reportedly described. And it refers to the Law Reform Parent and Child Scotland Act. That's back on page 217. The position as to persons who may exercise parental rights is regulated by the 1986 Act, which abolished the legal distinctions between children born in and out of wedlock. However, in relation to parental rights, a distinction persists, as is apparent from section 2.1, which provides a child's mother shall have parental rights whether or not she is or has been married to the child's father. A child's father shall have parental rights only if he's married to the child's mother or was married to her at the time of the child's conception or subsequently. Subsection 2.1 is in turn subject to section 3, which enables any person claiming an interest to make an application to court for an order relating to parental rights. The court, which is bound to regard the welfare of the child as the paramount consideration, may not make such an order unless satisfied that to do so would be in the interest of the child. The natural father of a child born out of wedlock, who is not automatically entitled under 2.1, may obtain parental rights, including tutory, custody or access, that was a definition then of parental rights, under this procedure by applying to either the Court of Session or the local sheriff court. Where the mother consents, the matter will be dealt with expeditiously. So it's said. And that's the background and the proposition upon which this case rests. Now, of course, if that proposition is taken away, if it's not well-founded, the case falls on that particular point. And, of course, what we've got in this case is a mother who doesn't consent. And there's no remote prospect of an expeditious grant of parental responsibilities and rights. And, of course, if the division are right, and of course I'm arguing they're not, the welfare test would have required to have been satisfied, and if the sheriff had granted an order simply on the basis of mother's say-so, it would have been incompetent and would have been subject to challenge by the principal reporter. So there's a measure of circularity. I tested this proposition in a case called L against H. I'll come back to McMichael, but if the Lords, my lady, care to look briefly at tab 33, they will see that attempt.
L against PH.
L against H, and it's tab 33.
Yes.
Just L against H. LL against PH, yes, yes. This was the classic unmarried father who wanted access, as it then was, and whose child was referred to the children's hearing. He'd had an action ongoing in the sheriff court. While the sheriff court action was ongoing, the child had been referred to the children's hearing, and he couldn't get into the hearing. And so he applied to the sheriff, and he couldn't apply for custody because that's not what he wanted. He wasn't aiming to take the child away from the mother. He couldn't apply for access, and at that point it was because the prevailing ruling was Dewar against Strathraidwick Regional Council, which said he couldn't. So he applied for the then equivalent of tutory, which was guardianship. And he said, please make me a guardian of the child, limited to going to the children's hearing. And that was refused. And in relation to McMichael, on page 93 at letter F,
Yes.
I can well understand why the defender, as father of the child, wishes to have a right to appear before a children's hearing. This is Lord Justice Clark Ross. In the course of her submissions, counsel for the defender referred to the European Convention on Human Rights. She also referred to the case of St McMichael against the United Kingdom. In that case, reference was made to the fact that the father of a child born out of wedlock was entitled to make an application for parental rights under Section 3.1 of the Act of 1986. It was held there was no violation of Article 8. And that was the end of the argument. So poor Mr. Lamb didn't get access to the children's hearing as a relevant person, or whatever it was then. if we go on through this, what we find is that the court did find a violation of both parents' Article 8 rights, interestingly, on the basis, this is on page 239, that the established case law of the mutual enjoyment by a parent and child of each other's company constitutes a fundamental element of family life. Domestic measures hindering such enjoyment amount to an interference of the right protected by Article 8. It would appear undisputed in relation to both applicants the care and custody measures resulting from the procedures complained of not only came within the scope of paragraph 1 of Article 8 but also involved an interference within the meaning of paragraph 2, and they referred to the procedural requirements and the problem that neither parent had seen the reports which had gone to the children's hearing. And interestingly, the outcome of that argument was there was a violation of Article 8. At 92, the government have already conceded in the context of Article 6.1 the unfair character of the care proceedings on specified occasions by reason of the inability of the mother or the father acting as a representative to have cited the certain documents considered by the children's hearing in the Sheriff Court. The court, taking note of this concession, finds in this respect the decision-making process determining the custody and access arrangements as regards the child did not afford the requisite protection of the applicant's interests as safeguarded by Article 8. Having regard to the approach taken in the present judgment in regard to the treatment of the applicant's complaints under Article 8, the court does not deem it appropriate to draw any material distinction between the two applicants as regard the extent of the violation found, despite some differences in their legal circumstances. In conclusion, there's been a breach of Article 8 in respect of both applicants. And that's the unmarried father who was at the children's hearing as the representative of the mother.
But it failed on Article 14.
Sorry?
Failed on Article 14.
It failed on Article 14, and that's the next part. And what was said there was 96. Under Scots law, a child's father automatically acquires the parental rights of tutory, custody and access only if married to the child's mother. Further, only a parent that is a person having parental rights is entitled to attend at all stages of the children's hearing. The natural father of a child born out of wedlock may obtain parental rights by making an application to the court. Such an application can be dealt with speedily if the mother consents. So we're back to the proposition that was seen at 77. Mr. McMichael was therefore in a less advantageous position under the eyes of the law than a married father. It has to be noted, however, that even after the mother was recognised him as the father of A, he'd never sought an order for parental rights, which would have allowed him the status of a party together with Mrs. McMichael in the care proceedings. According to the court's well-established case law, a difference in treatment is discriminatory if it has no reasonable objective justification and so on. There's a reference to the Scottish Law Commission, and it's axiomatic the nature of relationships of natural fathers with their children will inevitably vary from ignorance and indifference at one end of the spectrum to a close, stable relationship indistinguishable from the conventional matrimonial family unit at the other. As explained by the government, the aim of the relevant legislation was enacted in 1986 to provide a mechanism for identifying meritorious fathers who might be accorded parental rights, thereby protecting the interests of the child and the mother. In the court's view, this aim is legitimate, and the conditions imposed on the natural fathers for obtaining recognition of their parental role in respect the principle of proportionality. Now, what the court has focused on there is the 1986 Act and the obtaining of parental rights, not the involvement in the children's hearing, which I put before the court in this particular case. So what I say is the argument that I present to my lords and my lady is not addressed by McMichael.
I'm wondering whether when they use the word meritorious, fathers who might be accorded parental rights, that they had in mind some sort of a filter process. Eliminating, that the aim was to eliminate, as it were, hopeless and frivolous cases.
They're addressing, my lord, the issue of who should have parental rights. They don't seem to be looking at whether one should participate.
No, I understand
the
the distinction you're making, and you're saying that this argument wasn't advanced. I was just wondering what they were driving at here.
Am I right in thinking that they're probably driving at the fact that the initial allocation is mum alone, but there are ways in which dad gets parental rights,
yes,
either by agreement or by court order,
yes,
and those ways are the filter that enables the meritorious dads to get fully on board and filters out the rapists and the...
Yes.
Yeah. It's always the rapist who is given as the
there
example
aren't that
in
many
these...
of them, but they
yes,
do seem to rather...
they're always the example
Yes,
in this
yes.
sort of debate. But given their earlier focus on the fact that this dad could have gone to court and got an order, that must be what they're referring to in paragraph 98.
Yes, yes.
Potentially.
The reasoning is not completely clear.
No.
And that's one of the problems about McMichael, and it may be that the way we've read it is not the way that it actually addresses the issues before it.
I thought it was just, in those days they were sort of assuming that if you're a married father, then you would be sort of involved and so on, whereas the other guys might be, everything would range from ignorance and indifference right through, and if you made no assumption, which I think is the kind of argument I see that still is being made by the Lord Advocate in this case, and it's a very broad brush, but that's the distinction. But of course that becomes that might do when you had very few people who weren't, but once you have this huge, in that manner maybe a majority of people having children who are not married, it then becomes really rather difficult to say that most of these fathers are going to be indifferent to the welfare of their children.
Precisely so. But given the majority have registered the birth together
exactly.
Anyway. And of course I rely now on Zorniger and say, well, we do have to look at this again in the light of current conditions, given we're dealing with a living instrument. And given that we have now a better focused idea of what we're doing, and given that the jurisprudence of the European Court of Human Rights looks at Sahin and looks at Zorniger and says you do need to have a fairly substantial, this is me paraphrasing, reason for doing this. And you can't make an a priori assumption that these fathers should be excluded. That's reading matters very broadly on the basis of those two cases.
So if we're going to have a meritorious hoop, the married chaps have to jump through it as well as the unmarried.
Well, what can I say? It's really rather an unfortunate term.
Quite daunting, really.
Well, no,
wonders
Julius
whether one
reminded me
would
that Mr. Miliband might face with this.
Yes. Anything more out of McMichael?
No, nothing more out of Article 14, unless I can assist the court further. I can move now to my fourth proposition, which is the Article 6 one, and try and deal with that quite briefly. Now, Article 6 in my submission does bring a change of focus. So far, I've been arguing about the right to be involved in decision-making. But in my submission, the Article 6 case focuses on the substantive claim. This is where we shift to parental responsibilities and rights and contact. And if I can state my argument, it's like this. First of all, parental responsibilities and rights and contact are civil rights that are claimed by this father as father of the child. He doesn't have them, but he's making a claim for them. And he's been making a claim for them since 2004 in the Sheriff Court. He's engaged in a contestation or dispute in relation to those civil rights. His dispute, the claim is disputed by the mother. So we have a dispute. He's entitled to a fair hearing of his claim for parental responsibilities and rights and contact. Effective control of that claim currently rests with the children's hearing, while this child is subject to supervision requirements, because they control the exercise of contact in particular, and other aspects of parental responsibilities and rights. The control of the children's hearing may be only temporary, but it has had and is having an irreversible and damaging effect. And I'm drawing now an analogy between the matters that were dealt with by both my Lord Sir John in the Court of Appeal and by other members of the court in the House of Lords in Wright against the Secretary of State for Health, which is at tab 44.
Tab number?
The right case, it's a tab 44, and it concerned the listing of persons unsuitable to work with children. Now, the difficulty in the right case were, as I understand it, workers were included on the list on a provisional basis before they'd been given a hearing. And this was challenged under Article 8 in respect of their right to respect for their private lives. I don't need to get into the facts of the case, given it's rather a different aspect of Article 8. But what was said at paragraph 21 by Lady Baroness Hale was that some interim measures have such a clear and decisive impact upon the exercise of a civil right that Article 6.1 does apply. It's one thing temporarily to freeze a person's assets so he cannot divest himself of them before an issue is tried. It's another thing to deprive somebody of their employment by operation of law. If Article 6 applies to the suspension of a doctor from medical practice, as in Leconte, it must apply to the permanent separation of a person from their current employment. And I would say, by analogy, it must apply in relation to the separation of a parent or child who are entitled to mutual enjoyment of one another's society. And then if I can move on perhaps to paragraph 25, where the lady refers to Lord Sir John, in considering there are two reasons why there was a failure to afford a care worker an opportunity to make representations before provisional listing could not be cured by the possibility of being taken off the list by judicial review or later access to a tribunal. The first was that denial of the right to make representations was not a mere formal or technical breach. It's a denial of one of the fundamental elements of the right to a fair determination of a person's civil rights, namely the right to be heard. He reached this conclusion having reviewed the cases, holding that the composite approach could be applied to deciding whether a person is fitted to pursue a particular profession or activity. In all these cases mentioned, the procedures followed by the initial decision-making body were such as to give the person concerned a proper opportunity of meeting the allegations made against him. Secondly, the detrimental effect of listing was often irreversible and incurable. Now, there are two particular aspects in which I draw support in this case, and they've already been mentioned, I don't need to go into them in detail. One was exclusion from a hearing prior to the Sheriff's order, and in particular exclusion when the grounds were established.
What period are we talking about? This is the early stage,
This is stage 2.
Because I'm just slightly puzzling over what we see in paragraph 20 and the idea of proceedings relating to interim orders, because one of the problems, as I understood your narrative, was what happened in 2006, two hearings where the father was excluded, really critical decisions were taken as to whether or not there was anything to challenge in the grounds of referral and so on, and he wasn't there. I mean, it doesn't strike me that these are really, as it were, interim. Obviously, what follows thereafter has a sort of interim character to it, but the really critical point where
in my case
he was missing was at the very beginning.
Yes, absolutely, yes.
So anyway, I mean, one quite sees the point about interim things, but this is a rather stronger.
My case is stronger as regards that initial hearing, but also if one's looking at the children's hearing and the supervision requirement saying, well, it's only a temporary order, it lasts for no more than a year, I'm saying, well, those months are critical in the relationship.
I mean, what did the inner house hold on this matter? It's not quite clear. What did they say, Mrs. Scott?
In relation to Article 6, but what the inner house said was the man has no Article 6 rights. They just said Article 6 doesn't apply.
That was because he hadn't applied. Is that
Well,
right?
he had applied. I am at a loss to understand the position of the inner house on Article 6.
Well, because he didn't actually have a right,
Yes,
but was applying for one,
all right.
He didn't have any Article 6 rights.
Article 6 doesn't apply.
That seems to be the point in paragraph 78.
I'm at a loss.
I mean, your simple point is, just so I understand, your simple point is when he was in the sheriff court, he had and had not, depending on what stage, a right of
Yes.
contact,
Yes.
whatever it was.
Or whatever.
And that one might think was some sort of a private law right of some sort, civil right of some sort. And then you say, along comes the children's hearing, and that interferes with that. And you say,
Well, this is Article 6, and it's the right to a hearing. And I'm claiming that I have Article 6 right to a hearing, and that I'm being deprived of the hearing by what's happened in particularly Stage 3
it must
and
be
4.
for the determination of a civil right.
Yes, yes.
And the civil right, I'm sorry, I'm just trying to follow it. You say that in the sheriff court, where he was and was not having contact, that was a civil right, isn't
I
it?
don't need to go that far, my lord, because he's looking for determination, isn't he? He's looking for contact. He's gone with an application for contact.
Yes, but I mean, they were determining a civil right.
Exactly so. So there they
So
were
Article
engaged
6.
in the determination of his civil rights, and they're cut short by the children's hearing.
And then the division will say, well, that isn't. The children's hearing isn't for the determination of civil. Is that right? I mean,
No, what the children's hearing said is, what the division appears to have said is because he didn't actually have any order from the sheriff, he didn't have a civil right. And I'm saying, well, I don't need to go that far. I'll come back to that point because I dispute that point. But I'm saying is he'd actually asked. He'd gone for a determination.
Well, I think they accept that before a children's hearing, decisions could be taken which would affect civil rights.
Yes, yes.
It's just that the father had no right to be there, and he hadn't anything vested in him, and therefore he can't complain. Because he's an absentee, and it's a process that takes place without him.
Provided you can get somewhere that suspends your process before it's been determined, then you haven't got Article 6 rights. Surely, if you're looking for a hearing of a right of contact, you're looking for a determination of your civil rights.
Well, you've a right to have the suspension set aside anyway, haven't you?
Yes,
You've a right to apply to have the suspension as a minimum.
But there must be quite a lot of situations in which you don't currently have the thing for which you're asking a court.
yes.
If you're asking a court for money, you don't currently have that money, but what you're wanting is the right to that money.
Well, Article 6 is about the hearing of the determination of that point.
Exactly, it's the determination of whether you have the right or not.
Yes, yes. And actually, I can go further than that, of course, because on the basis of my lord's and my lady's decision in Ries, perhaps I should qualify that a little. Sorry. Tab 47.
47?
Yes. I regret to say that this is my lord's house setting aside the Court of Appeal. And the issue in this case was whether the Court of Appeal were correct to impose a process on care orders which brought them back before the court to check that all was well. That's putting it rather crudely and perhaps not particularly elegantly.
Turn them into something more like Scottish supervision requirements.
Quite so. To which one hopes everybody can have access and be involved in the decision making. But the point here is at taking matters very short at paragraph 71 at 320 in the speech of Lord Nichols.
Yes.
Although a right guaranteed by Article 8 is not in itself a civil right within the meaning of Article 6.1 of the Human Rights Act, it has now transformed the position of this country. By virtue of the Human Rights Act, Article 8 rights are now part of the civil rights of parents and children for the purposes of Article 6.1. This is because now under Section 6 of the Act, it's unlawful for a public authority to act inconsistently with Article 8. So what this does is transform the appellant's Article 8 rights into Article 6 rights because they're now recognised by the Human Rights Act. So inherent now in civil rights for the purpose of Article 6 is recognition and respect for family tie, mutual enjoyment of a parent and child of each other's company, protection from arbitrary interference from public authorities, and so on, the whole list. Is a civil right, are civil rights.
Well, I keep looking back at paragraphs 78 and 79 of the First Division's reasoning, and I think what they're saying is it's not at all unusual to have a two-stage procedure where you have to qualify under one procedure before you can be admitted to the other procedure. That seems to be the point, really. And they say, well, your complaint is directed to procedure number 2, you failed to qualify under procedure number 1, and therefore you haven't got a ground of complaint.
Well,
I think that's the reasoning which is expressed there.
Well, I've stated my argument as to why that's incorrect, that first of all I'm looking for a determination and second I have a civil right. But I supplement that by saying that they're quite wrong to take refuge in Michael, because what one sees in Michael is that unlike Keegan, this man has not made an application.
Yes.
And if one looks at Keegan, and perhaps we ought to look briefly at Keegan, at tab 62. Sorry, 61.
We're looking back at Keegan, tab 61.
Tab 61, Lord.
Yeah.
The Lords and Lady will recall that in Keegan, the problem was that the unmarried father couldn't challenge the child's adoption in the adoption board because he didn't have parental rights, and therefore he had to go off and ask for guardianship, which is exactly the situation, or analogous to the situation that we face here. And that circumstance, the court held, was a violation of Article 6.1 at paragraph 56 and following. The reasoning is very brief, but that's clearly what they're about. It says that compliance, the government submitted in the first place that the adoption board was not a court, and thus the fact the applicant had no statutory right to be heard by the body could not infringe this provision, Article 6. Secondly, it was open to the applicant to apply to the courts for guardianship and custody of his daughter, which he did. Since these proceedings controlled and determined the activities of the adoption board, which can make no order, that it has no notice of such an action, Article 6.1 was complied with. In the court's view, the adoption process must be distinguished from the guardianship and custody proceedings. As has been previously observed, the central problem in the present case relates to the placement of the child for adoption without the prior knowledge and consent of the applicant. The applicant had no rights under Irish law to challenge this decision either before the adoption board or before the courts, or indeed any standing in the adoption procedure generally. His only recourse to impede the adoption of his daughter was to bring guardianship and custody proceedings. By the time these proceedings had terminated, the scales concerning the child's welfare had tilted inevitably in favour of the prospective adopters. Against this background, it's not necessary to decide whether the adoption board, which admittedly exercises certain quasi-judicial functions, is a tribunal within the meaning of Article 6.1. There has thus been a breach of this provision. It's not teased out, but it's quite clear, and one can understand why the court held that there was a breach of Article 6, and it's very similar, it's analogous to the present case. And of course, it is of significance that in the recent case of Authority Reporter against S, and I don't want to take my lords back to it unnecessarily, the extra division in that case held a breach of Article 6 in respect of fathers who had contact orders but didn't have parental responsibilities and rights. I've taken matters fairly fast. Yes, Learned Junior points out that, of course, it wasn't actually in dispute in the inner house that Article 6 applied. I think he'd taken as read, so that was another reason why the decision of the First Division was something of a surprise. Having taken that rather fast, might I be permitted to conclude with what is said on behalf of the appellant in relation to reading down?
So we're on the last point.
Indeed, yes. And I take my point of reference, my Lord's decision in the House of Lords in Guyton against Godin Mendoza. And do I need to refer the Lords to...
Well, we're very
the
familiar with the decision. I think we just need to look at the wording, don't we, and decide whether we can do something with it.
Yes, indeed, yes. And the Lords will be aware that the extra division have already performed an exercise in relation to the wording on this.
Yes.
What I have done in the case is to offer two possible approaches to reading down. One is the simpler of the two and simply suggests that any parent could attend the children's hearing. And the other is a more limited and refined possibility.
And this is what we see at paragraph 3.2 of your written case.
Indeed, sir.
Is that right? So we just see it in front
What
of
I
us.
would submit in relation to either of these is obviously they must go, any reading down must go with the grain of the legislation. That was what I take from Guyton against Godin Mendoza. And what I say one can take comfort from in reading down is if one looks back at Kilbrandon and looks at the intention to enlist the cooperation of parents, then one can deduce an inclusive rather than exclusive intention for involvement. If one says that the grain of the legislation is to include those persons who have a contribution to make to the hearing, that again has to be taken into consideration. And if one's looking at giving the legislation the meaning as intended by Parliament in terms of Section 3 of the Human Rights Act, it's my submission that it should be read so as to involve in the hearing the right to respect for family life. That should be without unlawful discrimination on the grounds of unmarried status, and include those who are seeking a determination of their claim in relation to parental responsibilities and rights or custody, or contact, sorry. The arguments for the more straightforward reading, which is simply to include all parents, is that it would deal with all the arguments in terms of Articles 8, 14 and 6. It would follow the model within the Children's Hearing Scotland Act of social work involvement. It allows consistency with the education legislation, and it brings the children's hearing into line with other fora in relation to matters relating to children. The suggested drawback that's advanced by the reporter is that it would allow all parents to be heard.
Sorry, it would allow?
All parents to be heard.
Yes.
And my reply is, well, they'd be entitled to be heard if this was an application elsewhere. And it can't be assumed that they have no contribution. There is one error, with great respect, in the reporter's case, which is that persons whose children had been adopted would be entitled to be included. That's not the case, and that arises from Section 40, subsection 4 of the Adoption in Children Scotland Act of 2007, and I've included that in the papers. The other objection which is raised is that being admitted to the hearing is a right, but it's also an obligation, and there is a criminal sanction attached. And my answer to that is, in terms of Section 45(8)(b) that we've already looked at, the obligation to attend flies off if the hearing is satisfied it's unreasonable to require a person's attendance, or that his attendance is unnecessary for the proper consideration of the case. So, in my respectful submission, the argument as to criminal sanctions really carries no bite. If somebody doesn't know they've got to be there, it's not reasonable to expect them to be there. And if they've not got a contribution, then they have no obligation. When it comes to option 2, my Lord and my Lady have two approaches. One is proposed by the Lord Advocate, and one is proposed on behalf of the appellant. And they could be viewed as trying to achieve rather similar objectives. The Lord Advocate's proposal is that there could be included in section 93(2)(a), after the words any parent enjoying parental responsibilities or parental rights under Part 1 of this Act, or whose participation at a children's hearing is necessary to ensure compatibility with his human rights and fundamental freedoms.
So this is paragraph 3.3 of that.
Indeed, yes. Now, I would have no difficulty with that. That would serve the purposes that I seek to argue. The only qualification that I would place on that is it actually puts rather a responsibility on those who have to make the decision. And one's looking here at reporters who are not necessarily legally qualified, and also children's hearings who are lay persons. What I had proposed to achieve the same sort of objective, although my proposal might be viewed as too narrow, is that one could look at section 93(2)(b)(c), which involves a consideration at the moment of whether a person has care or control, and add on to that.
It's the phrase there appears to be, is it?
Yes, that's right. So you'd look, appears to be a person who ordinarily has care and charge of or control over the child, or appears to be a person who has a defective family tie with the child, or a claim one could add in relation to parental responsibilities or rights. But the reason that I thought that the locus could be there was because the hearing was already accustomed to having to determine who should fall within that definition, and I've cited some cases on that. C against Kennedy was perhaps the first such case where the hearing or the sheriff looking at a children's hearing case had to determine whether somebody fell within care and control.
You say that would catch all the people who are...
It would catch the Article 8 people.
Oh, no,
Yeah, it wouldn't necessarily catch the Article 6 people.
No.
But the matter's in my Lord's hands, and I think we're all agreed that the very, very last resort would be a declaration of incompatibility, that if the section can be read down to make it compliant, the court would, of course, do that under its obligations in terms of Section 3, yes, subject to subsection 4.
Now, we're dealing with a statute which would be in the hands of Parliament in London. Is that right? I mean, it wouldn't... I mean, I'm searching really for guidance, what the effect would be.
Well,
a lot of this is legislation which is under the control of the Scottish Parliament, but would this actually...
It's devolved. This is a devolved matter. The original legislation was a London...
Yes.
The Children's Scotland Act is a London Act.
Yes.
The Westminster Act. The other matter I should probably draw to the Court's attention is that Part 2 of the Children's Scotland Act is currently subject to debate in the Scottish Parliament, and there is a Children's Hearings Bill which is within the papers. One doesn't need to look at that at the moment because it's not law.
Yes.
Clearly, the Parliament would have to take into account any decision of this Court in relation to what it did with that bill.
What does the Scottish Parliament's bill say about this matter? Does it say anything?
It does. Oh, yes, it does. It's at tab 75, and I'm conscious that the bill team are in court listening to the debate.
Oh, that is je ne sais quoi for the whole thing.
Where are we looking at?
Tab 75.
It's tab 75.
Yes.
It approaches the matter in two ways. In clause 185, on page 81, it defines relevant person much more narrowly than the current definition. It defines relevant person as a parent having parental responsibilities or parental rights in relation to the child under Part 1 of the 1995 Act, but then qualifies that at subsection 2. For the purpose of subsection 1A, a parent does not have parental responsibilities and rights merely by virtue of an order under 11(2)(d) or E, and that's a contact order or a specific issue order. So it narrows the definition. And this section does not include those with care and control, but there is a separate section which potentially brings those people back in. And that is section 80, or clause 80. This section applies where a matter mentioned in 78.2a, a relevant person claim, is referred to a meeting of a pre-hearing panel or a children's hearing. At 3, the pre-hearing panel or children's hearing must deem the individual to be a relevant person for the purpose of the children's hearing if they consider the individual has or recently had a significant involvement in the upbringing of the child. So there's a deeming provision. Neither of the sections, the clauses, would help the present appellant because, of course, he hasn't had recent involvement, although he had substantial involvement before the hearing became involved.
What's the, maybe it's not for you to say, but why is it done this way? Why does one have to, is in order there should be control as to who has had a significant involvement, is that right? It's deemed to be. I mean, they're not relevant persons.
No, they're not. It maybe it's a slightly obscure way of framing it, but that's the current form of the bill, as I understand it.
So we would be leaping over that if your proposal was accepted. And
on one view, it's already been leapt over by Authority Reporter against S because the exclusion of the person with a contact order cannot stand. And the Parliament obviously will have to re-debate these items.
And is there any hint as to why this particular policy is being put forward?
I'm not in a position to assist. It may be that Mr Johnson, on behalf of the Lord Advocate, can assist.
How far has it got?
It's gone past stage 2, as I understand it. It's in stage 2 now.
In stage 2.
But of course, it's the appellant's hope that he will be able to go to the children's hearing and also to pursue appeal if he can't have contact. I should briefly mention that the appeal that he originally pursued fell because it was superseded in the course of time. Now, unless I can assist my lords and my lady further.
Well, thank you very much indeed. Miss Sterling, do you have anything to add?
My lord, my lady, I have nothing to add.
Now, Miss Clark, I think it's your turn, isn't it? Would you like to move the lectern over
Can
to
you
Miss
agree
Clark?
that perhaps Miss Clark might find it easier to address my lords and my lady from the middle rather than the wing? I'm prepared to move.
If that is acceptable to my lord and my lady.
Choreography. Much improved choreography.
My lords, my lady, I appear on behalf of the second minuter,
Yes.
who's the curator ad litem to the child, and respectfully adopt the submissions for the appellant, co-add the first and second issues, and in part in respect of the third issue, and that's with regard to the reading down of section 93.2b. There is a point of departure there, which I will come to. It is quite plain that the curator ad litem approaches this matter from a rather different standpoint, and that is in connection with the perspective of the child. And what I would propose to do, rather than to incur any duplication with regard to the submissions that my lords and my lady have already heard, is just to limit my submissions to broadly 3 chapters, and that would include the interest and rights of the child. Secondly, the child welfare hearing on the 27th of October 2006. The interlocutor, the product of that hearing, of course, is focal to the matter of competency. And thirdly, and briefly, the point of departure in connection with the reading down.
Yes. Well, we have the advantage of your written case anyway, which presumably you adhere to.
Yes, indeed,
Yeah.
my lord. With regard to the issue of competency, I can just submit very briefly that it is the curator ad litem's position that it is sufficient for the competency that the Sheriff, Sheriff Totten, applied the overarching principles, which is section 11.7, obliging him to consider the welfare of the child, to consider whether there ought to be an order made. And also the matter proceeded on the basis that the child was of insufficient age or maturity to form a view and to contribute that view. I think it has already been identified that it does not seem to be in doubt that the child and the appellant had the benefit of being part of the same family unit. They were members of that family unit. They had a bond within family that attracts the protections of Article 8. And my lords, my lady will see that flowing from that is the entitlement, not just of the appellant, but of the child to respect for that family life. And that what that entitles the child to is the enjoyment of the company of her father. And that enjoyment, of course, is mutual. That is an entitlement that it attaches to the appellant also. I would also submit that it is the respect for the family life of the appellant and the child extends to the potential relationship, and I think that has already been touched on, and authority for that is in the case of Nyland against Finland, which is at tab 67. It will be easily identified from the Statement of Facts and Issues that a feature of this child's life was residential contact with the appellant for a substantial period of her young years. Residential contact operated until December 2005, which was the time when the allegations were first made against the appellant, and that residential contact, in fact, took place every Friday from 10 o'clock until Saturday at 6 p.m.
There was the initial period before the separation, obviously.
Yes.
And then after that, there was an order made, which was the interim order in, was it May 2004?
That is so, my lord.
And that was implemented. I got my dates right.
That is correct, my lord. I think there is some debate between the parties as to the actual date of separation.
Yes.
And of course the curator ad litem is not in a position to clarify that. But certainly we have a situation where at least from May 2005 until, May 2004 until December 2005, it was a feature of this child's life that residential contact operated every weekend, which of course is a fairly persistent feature. And that in addition to that, there was further contact arranged between the parties. At the point where the contact was interrupted, the child, by my calculation, was 3 years and 7 months of age. And it would appear that a fairly constant feature of her custom, of her life, was the appellant and his interaction with her. Following the allegations that emerged, I think on the 29th of December 2005, there developed a fairly turbulent period in the relationship between the parties. And despite the separation, my lords, I think it is fair to say that there had been an apparently tolerably harmonious period prior to that. So what had been a situation that parties could navigate through became a very conflicted situation between them. And it is at this point that the right to respect for the family life of the child is most vulnerable, and that is the submission. And what I think is rather important to identify is what in fact occurred from May 2006 until October 2006.
And we assume that at some point in December, we don't seem to have the interlocutor, but there's an interlocutor recalling the order for contact, is that right?
No, my lord.
No.
As far as I understand matters, what occurred on the 29th of December was an allegation against the appellant. The interlocutor recalling the interim contact order did not, in fact, take place until the 5th of May 2006. And my lords will see that in the appendix at page 104.
Yes, thank you. So in fact, it stood until then? Yeah.
Yes, indeed, my lord. I think as a matter of fact, however, contact did not...
I noted you just a moment or two ago saying that the order operated until December 2005.
Yes.
Did it actually run on until it was actually suspended?
That is correct.
So it did run on into the following year then?
It did run on until the following year, until the 5th of May 2006. But in fact, contact did not take place following the allegation on the 29th of December 2005.
So, sorry, I'm not sure I fully understand that. It was necessary for the order to be suspended. Was that because it was actually, there was an attempt to exercise the contact, which was being frustrated, or what was the position?
I believe that what occurred prior to that, my lord, was the situation which resulted in the charge of plagium.
Yes.
And removal of the child for a brief period of time. I think this was resolved within a matter of hours, is my understanding, and that resulted in the plagium charge for which the appellant was admonished. And I believe that occurred in the March 2006.
Yes. So would it be right to say effectively from December onwards it wasn't really a runner? Although the order was in place until it was suspended.
That is the case, my lord, and what occurred on the 5th of May 2006 was that the curator ad litem, prior to her appointment as curator, was instructed by the court to report upon the upbringing and circumstances of the child. Right. My understanding is that it was only after the matter of plagium and removal of the child from the mother by the appellant that the child was in fact referred to the children's hearing, and it wasn't immediately following the allegations in December 2005 that occurred. So in March 2006, the child was referred to the respondents with child protection concerns, and that followed the plagium matter. In May 2006, the formal interim order was suspended and Miss Kelly was appointed to report. On the 28th of June 2006, the first children's hearing was held. A second children's hearing was held on the 20th of July 2006. And my lord and my lady have already heard that the matter went before the sheriff on the 11th of August 2006 in connection with the grounds of referral, and that the grounds of referral were deemed to be established without the leading of evidence and without any judicial inquiry into the substance of the matter that brought the child before the children's hearing.
And without the father being present.
And without the father being present or having any ability to involve himself in that. And I think this is where I would very strongly echo this issue of involvement. It was a matter of growing concern in the mind of the curator ad litem that the father was not invited to attend children's hearing. My understanding is that there was equivocation in the advice being given to the curator ad litem by the reporter's office as to how the father would be treated and whether he would in fact be invited to attend. And within the statement of facts that were attached to the grounds of referral, it was quite plain that there were many allegations directed against the appellant. This was not a matter that was to be developed in connection with the child that left the appellant out of the issue. He was very much part of the concerns that came before the children's hearing, that developed before the sheriff, and that were formalised in grounds of referral being established on the 11th of August, all without the appellant's contribution or influence. And that was a matter of particular concern to the curator ad litem. What occurred, my lord, and this is, I would suggest, quite significant, is that following the 11th of August 2006, when the grounds were deemed established on the 18th of August 06, just 1 week beyond that, at a child welfare hearing in front of the sheriff, interim contact was resumed.
Yes.
And the order was put in place for interim contact with the child, albeit, I understand, on a supervised basis.
And that took place, did it?
Yes, my lord. My understanding is that it did not take place for some weeks because there were logistical arrangements to be attended to with regard to supervision. But yes, contact on a supervised basis did take place.
And
The matter...
And then later, just about 6 months later, it was varied to allow further contact at a residential centre. So there was a continuing relationship during this period, wasn't it?
Yes, that is so, my lord. Contact took place, I understand, until 2007,
Yeah.
at which point the interim order was revoked.
Yes.
And I have to say that that was done with the support of the curator ad litem at that point. But returning to what I would...
So what, the revocation?
Yes, indeed, my lord.
That was in August 2007?
That is so, my lord. And I understand that contact, in fact, did not take place following June, and that the formalising of that was by interlocutor of the 3rd of August 2007. So we have the interim contact order being resumed of consent with the mother. So it appeared that on the 18th of August, all parties, including the curator ad litem, were content that there be a continuing relationship and a continuing contact between father and child.
So,
And-
so that's the 18th of August.
Sorry, 2006, my lord,
Thank you.
which is at page 107.
Thank you, yes.
I'm obliged. And fairly speedily following that, the matter returns before the children's hearing, and we have a situation that on the 19th of October 06, the supervision requirement is made. And that is, in effect, a declaration that the child is in need of compulsory measures of supervision, and that the children's hearing are thereafter able to be determinative of matters pertaining to contact. Although the situation, I believe, continued that they were content at that stage that the Sheriff Court retain influence over that matter. And it is following that, my lord, on the 20th, or my lord, my lady, on the 27th of October 06, that we have Sheriff Totten's interlocutor pronounced. And from that point, the appellant was entitled to be involved with the ongoing children's hearing process. So we have a span of a comparatively short period of time, I would submit, whereby what occurs is that the entitlement of the appellant to the interim contact order is suspended. At that point, the child enters the forum of the children's hearing, from which the appellant is to be excluded, because even on the developed understanding of section 93(2)b from authority reporter against S, he does not have the mechanism that would allow him access to the children's hearing. He is not a relevant person, and he does not at this point have a contact order in respect of his child. So we have at that point the very critical process from the child's perspective of establishing the grounds of referral, which, as has been heard, was done without inquiry. And then, from the child's perspective, the very critical step of deeming that that child is in need of compulsory measures of supervision by the imposition of the supervision requirement in terms of section 70.
I understood that the father was present when that requirement was made.
That might be
Not
correct, my
on the
lord.
19th of October.
That might be correct. His presence was gratuitous in the sense that it was something that he was allowed or permitted,
Yes.
in terms of the fact that he could be invited to attend, but he was devoid of a voice within that forum in the true sense. because he was, albeit he could be an observer, he had critically, and at this point, it does seem to be critical that he has no right of appeal against any decision of the children's hearing at this stage that a relevant person would have.
Well, on the 19th of October, they certainly did this, because it says it discussed it with both mother and father.
Yes, that is so, my lord.
But of course, he's in some difficulty at that stage because the grounds for referral have been established.
Had been established.
And therefore the argument has to take place on a basis which he doesn't accept.
Yes.
Nevertheless, the hearing
It
must
is-
regard as established.
Yeah.
Yes, indeed, my lord, and that is very much at the heart of my submission on behalf of the curator ad litem, that she considered at that time it to be very disadvantageous to the child to allow a set of facts to go forward to a point where they are deemed to be established without judicial inquiry, without scrutiny, without the contribution of the father. In a circumstance where those statements of facts were very heavily directed against him and his conduct. And it is perhaps rather easy to see and to anticipate that had he a legitimate part to play in that process, that we would have had a situation where those statements of fact would not have been accepted at that stage. There would have been a proof and some form of judicial inquiry and perhaps a fairer process from the perspective of the child to establishing grounds of referral. It is perhaps going too far, I do not know, because clearly it is very difficult to examine the merits of what might have occurred had the father been involved in that process. But we could have had a situation where there may have been a different outcome for the child. And if we have a circumstance where the natural father could have the capacity to influence the outcome, an outcome which is, in my submission, a determination of the civil right of the child, because we have the imposition of a supervision requirement ultimately, but we also have establishment of grounds of referral, that if she is denied his contribution, if she is denied the capacity for her unmarried father to influence that outcome, then that is a very real disadvantage to her, and one that, in my submission, is an infringement of her Article 6 rights.
Well, put bluntly, she's entitled to have a decision taken as to her future on an informed basis.
Very simply, my lord, and that is what it amounts to. And one of the matters that was very much exercising the curator ad litem at that time, given the situation of conflict between the parents, given the allegation that was made against the father, was that for him to be excluded from the forum of determination of what was a fact established for this child would be inviting a misstatement of established facts pertinent to this child. And that is perhaps the backdrop to the situation of the child welfare hearing that occurred on the 27th of October 2006. The other aspect of that, my lord, and it is perhaps a bit more focused, and I'm not certain as to whether we need to really develop it to this extent, but it did include within the statement of facts an allegation of abuse, sexual abuse of the child. And one of the very real concerns that the curator ad litem had, and this is within the written case, was that if there were grounds of referral established that made reference to an allegation of that type, which had proceeded without inquiry, that it would be detrimental to the welfare of the child to grow up, to go forward, and to develop in a false belief that she had been the victim of such abuse. And that it would be very much against her interests that that position be allowed to prevail.
Well, not only is there a possibility that she grew up in such a false belief, but the consequence might be that she would be deprived of the society of her father.
Yes,
when
indeed.
there was no testing of the allegations which brought about that result.
Yes, very much so, my lord, and it is quite extraordinary if one considers the very powerful forum of having grounds of referral and statements of fact validated by the sheriff without intervention, without judicial scrutiny, the powerful forum of establishing facts that could be quite mistaken in respect of a child. Now, it might be said that this whole process also includes the reporter's department, it includes social work intervention, it includes various commentators who may have a part to play in putting together the landscape upon which such a validation might occur. But what it excludes is the most vital contributor to that, and that includes the person against whom the allegation is made.
But their approach is conditioned by the grounds of referral, isn't it?
Yes.
And they can't argue with them any more than anybody else can once they're held to be established.
Yes, indeed.
Is that not right? I mean, the future planning of the child's welfare and so on takes place, I should say, against the background of apparently established facts.
Yes, that is so, my lord, and it is a matter of very real concern that if there is within those established facts, and I have to concede that the issue of the allegation of sexual abuse was tagged on at the end of the statement of facts, and there included a very great number of other allegations to do with hostility demonstrated by the appellant towards the mother and the child witnessing that. So there were a number of different and various allegations that fortified this approach. But
can I just be clear? The facts that were established, held to be established, are the ones which we see. Is that 154, 155? Is that true?
I believe so, my lord. Yes, indeed, my lord.
And the one you talk about being tacked on is number 8 on
It's number 8.
On 155.
Yes, that is correct. My understanding of this process was that there were additional statements with which the mother did not agree. Those statements were in fact deleted. And what we have here is a statement of facts with which she was content to agree. Clearly, it is, I think, fairly straightforward to presume that had the appellant the opportunity to be involved in this part, critical part of the process from the point of view of the child, that it is fairly likely that he would have disagreed and not accepted a great many of the statements that we see at 154 and 155. The situation, my lords, my lady, was that against that concern, the curator ad litem made certain submissions before the child welfare hearing on the 27th of October, and those submissions are paraphrased within the terms of the written case for the curator ad litem.
This is your narrative on page 3.
Yes, my lord.
Yes.
And the purpose of providing the court with that narrative is to allow the passing of information as to the scope of concerns that were existent at the time, at the critical time, and to perhaps indicate the level of discussion that developed before the court on that date,
Yeah.
and to illustrate the concerns that the curator ad litem had that it would be beneficial to the child that the appellant participate in any further decisions before the children's hearing. The interesting aspect of the hearing on the 27th of October is that what occurred before the court was, first of all, a motion for interim contact, and that was of consent, my lord, with the mother. So we have a situation where, even at this stage, on the 27th of October, there was no real suggestion that this particular father was not meritorious of the interim contact order, and that matters proceeded in discussion before the sheriff on that basis. We have the situation where the interlocutor was pronounced, and without wishing to in any way duplicate what has already been submitted before my lady and my lords, the court is empowered to make such orders as the court thinks fit. And there is a generality within the terms of the legislation that provides a latitude that I would respectfully submit establishes the competency of the order that was made before the court. And I think we have the situation where the Inner House were quite ready to recognise that an award of parental rights and responsibilities that facilitated entry to the children's hearing would not of itself be incompetent.
Now, it's pretty well time for us to rise. I'm just keeping an eye on your written case. I think we've dealt with the first issue. Is that right?
Yes, my lord, that will be right.
Second issue you want to develop a bit tomorrow. And is it the third one where you say there's a certain amount of difference between you and Ms. Scott?
I will be very brief on that
Yes.
point.
Right. Well, we'll look forward to seeing you all at 10:30 tomorrow morning.